Hello, everyone. It's kind of hard to do the graveyard shift, but we'll do it anyway. I'm Shwetasree. I'm the managing partner of Fidus Law Chambers, and I'm a career litigator for the last couple of decades. I litigate IP and a lot of technology.
Hi, everyone. I'm Poornima Sampath. I'm the general counsel for Tata Digital, which you may have used my super app. It's called Tata New. I lead legal litigation, IP, data privacy, and legal affairs for the Tata Digital Group.
Hi everyone, I am Satish Kumar. I am the General Counsel for Intellect Design Arena Limited. We are present in 92 countries. So ours is a banking product company. So I'm a global legal head, so I take care of all the legal issues. Thank you.
Hello all. Hi. This is Sonal Basu. I head the legal function for LTIMindtree, focusing on commercial transactions, governance matters, and IPR. I'm based in Bangalore. We have presence in nearly 40 countries. So we have plethora of interesting matters to deal with, which I support on.
Good evening all. I'm Anil PM. I'm the Senior President, Legal, Compliance, Fraud Prevention with an old economy company, which is into life insurance, the Bajaj Allianz Life Insurance Company. Happy to be here on this panel. Thank you.
Thank you all. So as you can see, what a diverse panelists we have. And I'm sure that each and every industry is touched by IP very, very intricately, and the issues are there. So my first question will be with Anil. Do you think there is an impact of digital shift on your sector concerning IP issues?
It is, no sector is immune to what is happening in business, what is happening in technology development. Same applies to insurance. When it evolved, and not too recent, you had the individual agent meeting somebody face to face. You filled up a proposal form. If accepted, you get a physical policy bond. Now, while that still continues, there's been a lot of transformation into the digital front. You have now apps which the customer fills. We kind of pioneered during COVID an application wherein, while people couldn't really meet the fact that we wanted to enforce transparency, so we had a screen sharing app which was developed where the sales agent is filling up a proposal form which is being seen live by the customer. Corrections they need to be made were made then and there. So it has been a huge transformation, and now we have the regulator mandating. We have EIA accounts, which is e-insurance accounts. So similar to your demat accounts for shares, insurance policies are to be credited. So as I said, we are not immune to the changes which have happened, and we really need to adjust to the new era. So IP, which was not too much of a concern, you had your brand, you trademarked it, you kept quiet, but now you have to be worried about, is there any digital breach, or any of your identity being misused in the dark web or anywhere else? So we have to be a little more vigilant in terms of what we used to do, and also the mediums which we need to focus on.
Thank you. My next question to Sonal is that with the recent issues, which is with respect to AI-related issue, and you wanted to talk about the risk management. What are the risk management faced with AI associated with IP in your industry?
That's an interesting question, and I think we all keep talking about AI because it has truly embraced our lives and the organizations in all sectors for that matter. Let's just take a step back and see what AI doesn't do, right? It recognizes images, it writes articles, it plays games, it is drafting contracts. So if practically everything has been done by AI, right? And which also poses a lot of legal issues, right? If let us take an example of ChatGPT, which again, everybody knows, what basically crops up, issues vis-a-vis usage of AI is, who is the owner of, if I were to take IP as an example, who is the owner of IP, right? There are infringement issues, there are user issues. So that's one. Second is there are issues to do with security. There are issues to do with data protection. There are issues to do with transparency. There are issues to do with biases, right? So what is it that we all need to focus on is how do you mitigate those risks? Because I don't think the adoption of AI is ever going to stop. This is just the beginning, and it's moving at a very fast pace. So it's important to create a lot of awareness amongst employees. If you're working for an organization, if you are working for a B2C company, you need to make sure that the adoption is done in an appropriate manner, keeping the legal framework in mind in terms of addressing the biases, addressing the transparency issues, and of course, looking at the framework which the AI Act is trying to implement. Creating a lot of awareness through trainings within the organizations is extremely important. And last but not the least is IP management. IP is a very, very important and vulnerable area, in my view. And if you do not create awareness and create policies to mitigate your IP exposure, it could really expose the organization, not only from a financial standpoint, but also from a reputational standpoint. So a lot of effort needs to go in from a risk mitigation standpoint.
Thank you, Sonal, for raising so many issues. I'm sure that will be very interesting answers here. Satish, may I ask you that what is the pain point in this digital era in protecting your IP in your industry?
Yeah, so the importance of IP cannot be underestimated. It's very critical, and more so in the IT industry. So basically in IT industry, you see that, IP is created very frequently, a number of times. But how do you identify the IP? That is critical. It is, the IP can be created by a simple programmer. The IP can be created by the CEO of the company. But how do you identify the IP? How do you register the IP? There is a risk. Huge risk is there if you are not able to identify the IP. There are examples where the competitors have stolen your IP and have, floated their own base of product that you have. So how do you protect the IP? This is very critical for any company and very important for a IT company where IP is created, I will say, on an everyday basis. So the criticality of IP cannot be underestimated. It's very important that you have adequate protection mechanism, and that is one of the reasons that I have a IP vertical in my organization, which is completely devoted on protecting the IP that is created in the organization. Because the general awareness of the IP is also very less, though it is growing. The general awareness with the programmers, that is non-attorneys, those who are not lawyers, the awareness of the IP is very less. So how do you build the awareness and protect the IP in your organization is the role of the IP team in any organization, and more particularly in IT industry.
Thank you for raising this question, because I think a lot can be talked on this topic as well. So I'll move to the next issue, which can be addressed by Poornima. As a super app, how do you address brand infringement in Tata Group?
Thanks for that. Let me walk you through some concrete examples that may give you a sense of what we do in Tata Digital and a bunch of other Tata companies. So Tata Digital sponsored the IPL. You've all seen Tata IPL for the last 3 months through the summer break. Preceding that, and even through that period, there were many, many brand infringement issues. So people would send fake emails to everybody saying, buy something on Tata Neu, and here's a free ticket for the box, the new box at Tata IPL. There were many emails floating around, stuff on social media. It wasn't an easy one. So we did a bunch of things, and frankly, I was ably advised by Shwetasree on a bunch of these matters. So one, we use a brand monitoring tool. It's called Cognac. I've been using it for the last 15 months, and we track infringement across, say, different social media platforms, whether it's on Insta, whether it's on Facebook, YouTube, Telegram, a bunch of these. And we give them search words. So it's Tata Neu, Tata Digital, new loans, new fintech, words related to my company. And when it's tracked, we figure what's illegal, what's an infringement, and we have that pulled down. So the brand helps with tracking. 2, I sometimes announce what are called the equivalent of bug bounties. So if somebody in my company comes and reports, hey, listen, we saw this on Insta and this looks fake, we try and reward them something. We also got what's called a John Doe order. It's, I've heard of John Doe, but I've never really used it for IP. I've only seen it being used in very cool Bollywood cases before movies are released. But we used it for our Tata IPL. She should actually explain more about it, but we went to the Delhi High Court and we gave them a list of domains, tatanew.co.in, tatanew.com, various permutation combinations, and we sought an injunction that restrains any third party from using it. 4, when needed, we go to the WIPO directly and tell them here's what we own. It may take time, it may take 2 to 3 months, but it also secures to us our rights. And 5, if there is a brand, if there's a domain that should rightfully belong to one of my Tata companies, I don't pay to get it back. It's just as a matter of policy. I'll give you an example. Tata FinServe and Tata FinTech.co.in was blocked illegally by somebody. I won't pay 6 lakhs to 10 lakhs to buy what is rightfully mine. I will litigate and I'll get it back. So these are some examples of what we've been doing in the recent past.
Thank you for that. So I think conventional John Doe matters have really improved big time. And as you're rightly saying that now John Doe is more dynamic in sense because you can file one suit and obtain injunction across India. So my question to Shwetasree would be that the new form of John Doe orders, I will not, because John Doe is an old concept. The new form of John Doe orders which have been used recently in many cases, I think including in famous Nestle case where 300 raids were done and many others. What do you think, where has been the shift? Is it the shift in the mindset in the judiciary to protect the consumers and the end users along with it's an indication of collaboration with the effort of the brand owners? How do you react to that? One. And second question, she talked also about website blocking. And I know for sure that you did one matter which has been a landmark judgment. So can you talk about that John Doe, the advanced form and the website blocking matter?
Sure. Thank you, Mamta. I think the answer to your first question is twofold. I've always said this, that, when it comes to infringers or counterfeiters, the only way you'll be effective, in taking legal action is if you're 2 steps ahead. So a traditional approach of waiting and the whack-a-mole approach, you wait for something to crop up, whack it, and it goes back in, doesn't really apply in the internet age where proliferation is the key word. So it's like our courts very eloquently call these bad actors as hydra-headed monsters, because you cut one head, of the proverbial hydra and 5 more crop up in its place. So adapting court orders to respond to these situations was a necessity. If you're looking at where it starts, you have all of these broadcast reproduction rights in relation to, say, cricket matches or films, where you have a whole bunch of websites that start pirated, versions that they start broadcasting. So starting from there, and today, obviously with e-commerce being the way it is and how much it's grown during the pandemic. So you even have in the product ecosystem, you have a lot of websites that are, selling counterfeits. And also, when it comes to the digital domain, whether it's credential harvesting, phishing, whether you're looking at franchise scams, you're looking at service center scams, job scams, or plain old lucky draws. So you have all of these kind of instances where the traditional IP domain has been tweaked to find solutions. So because at the end of the day, if someone is committing fraud and telling you that, look, I represent so-and-so bank, and your money, you have to transfer a certain amount of money or whatever, some dues, ultimately the bank's trademark is being used. So you can locate something that falls purely in the realm of fraud within the IP domain. And why you would do that is because if you're going straight to the police as a consumer, then the police are going to investigate. That machinery will take some time to turn the wheels of that system. When you go to court, I think what we've seen, and this is this segues to what you were asking me, is that courts have been very responsive in finding A, commercial and B, collaborative solutions. So when a judge says, okay, I see the problem, I need to find a solution, and I need everyone to come on the same page. So here, what a judge is doing, and especially the Delhi High Court has been the leader as far as this space is concerned. The judge is, for example, issuing orders to the Department of Telecommunications and MIT to shut down all the websites through the network and the internet service providers. So that's one level done. Second, it's issuing orders by which phone numbers are being blocked by all the telecom service providers. So that's level 2. So all the tools through which, or the vehicles through which the fraud was being perpetrated are all being shut down. Then you've got your payment gateways. So that's where all the intermediaries are being held accountable. You've got your payment gateways and you've got the domain name registrars. Courts asking both the payment gateways and the domain name registrars to reveal the KYC particulars of the actual folks who are behind the whole enterprise. So you're getting those KYC particulars, courts are calling the police and saying, now investigate. So look at how the whole ecosystem is therefore being addressed. And until this was happening, you weren't really getting a solution that was sufficiently holistic. And obviously when this sort of an approach is taken, I mean, we get John Doe orders where we get 300 to 500 domain names shut down in one order. So that obviously also from the point of view of a company is a great return on investment, because you're filing one litigation and you're getting all of this addressed simultaneously through a creative approach. So I think as a litigator, I can say this, that the courts have been receptive to creative problem solving. And that to me is the big win. And as far as website blocking is concerned, yes, we're currently in appeal in a matter where we're pushing for greater domain name registrar accountability as well, to the extent of saying that, you know, if in a situation a particular domain name registrar, despite knowing that there are certain rogue actors, is continuing to allow them to register more and more domains with the same trademark, then shouldn't the registrars themselves also be accountable over and above the registrants? So all these questions are now being asked by the court.
Just to add to that, that India is number 3 in the world after Milan and Singapore, who passed the dynamic injunction to address the rogue websites and curb the piracy. And so far, as per the data, 11,500 domains and websites have been blocked. So this is absolutely a very progressive movement. And I will say the Delhi High Court is, and also other high courts, I would say Mumbai and Chennai, have been really very progressive. So my next question to Anil is, Anil, you talked about impersonation and, dark web issues in your industry. So have you ever tried takedown mechanism, and what has been your experience, if at all, with the intermediaries? Is it satisfactory, or do you see any pain point?
So the financial services sector, insurance included, has been besieged, or rather the customers have been besieged with fake calls. And, having seen a lot of these cases, we are also surprised as to how much amounts which get paid in some of these scams. Very recently, we had a case referred by the ministry, the DFS rather, where an individual has paid 2.5 crores. 2.5 crores paid over a period of 4 years. The first promise was you will get a 5 lakh bonus in a policy which was paid out 10 years back. And this continues, and this is a one-off instance. I mean, this is not a one-off instance. We've been having a lot of these issues. So we proactively, obviously, one is creating awareness, creating education, working with the authorities, be it law enforcement, be it the judiciary, in terms of getting orders passed. We are trying to have, especially in Gujarat, we found, a lot of fraudulent claims are being made where there's a lot of connivance between the authorities. Deaths are forged with, the death certificate being issued. You have proper medical hospital records when that person has not even gone to that hospital. So we are trying to have special investigation teams formed which will look into this. As far as call centers are concerned, we had a lot of issues in the north, especially the Noida, Gurgaon, the NCR region. We work with the law enforcement there to have these raided. So John Doe orders, we really have not got much of these, but we directly work with a lot of these authorities, law enforcement authorities, and obviously the telecom authorities, because the numbers which get used or rather misused, we try and block them so that they're not repeated. So this is, something which is there. Definitely look forward to looking at where we can get judicial intervention also to give a little more effect, because all of these working one-on-one with the regulatory authorities, the police authorities take time. It needs building that relationships, being at it for a very long period of time for them to move, having to educate them as to what is an insurance fraud, what is the financial loss cost. So all of those issues. So, but it's something which we don't want to give up and we don't want to take it lightly, because at the end of the day, it is the customer's money. We are the custodians of that and we need to protect it.
Thank you. Sonal, do you have any pain point in terms of online infringement and the takedown mechanism or functions of the intermediaries?
Yes, we do have. I guess nobody has escaped that problem. So we do have a lot of fake domain related issues. We also have had personification issues. I think that's become a common problem of late. And of course, we do get help from able advisors such as Shwetasree and others to deal with those problems. But I guess to really combat these problems, it's important to have a cross-functional setup, conversation within the organization. Your CISO should be talking to your CFO, should be talking to your, GC, should be talking to your data privacy officer. So if you have a good, robust governance mechanism within the organization where all the right stakeholders are having right conversations at the right time, I think those conversations definitely help implement right set of technologies, tools to prevent some of these vulnerabilities. That's one. Secondly, it's also important to make sure that the solutions that you're implementing within the organization, which could at times, create these vulnerabilities, are also implemented keeping in mind the InfoSec and the privacy by design aspects. So then to a certain extent, and of course the right firewalls to a certain extent, that also helps prevent these issues. But yes, I guess all the organizations are vulnerable these days.
Sure. Satish, my question to you would be that you pose the challenge that how to protect. And there are several aspects of IP, right from trademark to copyright to design to domain names and every other aspect. My question to you that which is the area specific to your industry where you feel that you face the challenge most, because then we can ask some answers here and get some discussion on those issues.
See, I feel for a software industry, the source code is very critical.
Yes.
So, there are source code which is being developed on a everyday basis. So how do you protect? Because, the source code now, you see a programmer is also, developing a source code. And this programmer who is today in your company can get a job in a competitor company tomorrow. And there is a high risk that this source code, he takes this source code from your company to the competing company. And, the competing company will be very happy to double his salary because they know that he is going to bring in the source code. This problem, we have been facing, and it's very critical that we have a robust IP policy within the organization first. That is very critical. Any organization, any industry, I feel that first you should have a very robust IP policy which will address various life cycle in a IP stand, right from development of the IP to enforcement of the IP. All through it should have various facets to protect the IP, how the IP is developed, when it should be registered, when it should be brought out to the public, or when it should be, how do you bring the general awareness of the IP within your business team. So I think that is very critical to have a robust IP policy, which will also have, which will also help in protecting and at the end enforcement of the IP in your organization.
Thank you so much for flagging this source code issue, and of course it is copyright protectable and confidentiality, but I would request Shwetasree to discuss that what is according to you the best protection which can be provided to a source code, and how to address the enforcement part if somebody breaches the confidentiality or breaches the employment term of confidentiality. As you know, the protection to employment is very weak. So how do you address that?
So we had a very interesting case which we ended up litigating, where somebody had a tech solution in relation to parking, and it's a very well-known company which has this parking tech solution deployed in residential buildings, commercial buildings, etc. So there was one of the engineers in the team, and this is reported, so I don't have a problem discussing it. So one of the engineers in the team basically sought employment, and this is one of those work from home risks, sought employment and became a consultant simultaneously with the competitor, to the extent that he was paying TDS in both. I mean, there was TDS deductions happening from both employers as far as he was concerned. So it was that brazen. So he was working with the competitor as well. And he was essentially passing on not just the technology, all the bugs that were getting fixed, all of the advancements, all the developments that were happening, but all the details, all the tender pricing. He had access to everything because of his login, because he was a senior member of the team, and all of that was being passed on. So there were ways in which traps were laid, and, evidence was collected of what was going on. And then a trade secrets and breach of confidentiality, violation lawsuit was filed. And I have to say that this is an area that I have personally seen grow so significantly. I've spent 2 decades in the profession now, and I have litigated more trade secrets and breach of confidentiality cases in the last 5 years than I've done in the, previous 15. And that's because there are these domains that don't fall within the traditional, framework of IP, which have to be addressed through these creative ways, and courts understand that, so you pitch it effectively, but there are ways to address them. All of these, provided you have the evidence. Ultimately, it's all about good policies, good paperwork, and gathering that evidence.
Yeah, I completely agree with you. But just to answer your question, your source code is copyrightable, and you can protect it through copyright. It is kept confidential. There is a mechanism to that. But yes, of course, the litigation has grown a lot. And I personally had handled a publishing house where, the app was prepared for one company, but ended up launched by competitor company by sharing the source code. So these are the issues, but there is a efficient mechanism to address and prevent such happenings. So my next question to you, Poornima, that you talked about that the Chandu orders. So that is one part, but your other issues which you have faced specific to your industry in terms of infringement or protection, which you feel very important for in the field of publishing and media and entertainment. How do you crystallize that this is one issue which is the pain point for you?
I think any infringement is a pain point, because the Tata brand belongs to my parent company, Tata Sons. It's one of the world's widely respected brands, and we do whatever we can to protect it. Many of my companies, and for instance, Tata Digital, like she correctly mentioned, we have a cross-functional committee, right? It's a cross-functional IP steering committee and a cross-functional information security committee. It's got the CFO, the general counsel, the head of risk, most importantly, the chief information security officer and the chief technology officer. Every month, as the GCI actually present, here are all the technology contracts that are in the works. Technology is the bedrock of any young company. And I present to them to get their thoughts on how best to protect internally, right? Do we enter into a SaaS agreement or a license agreement? I prefer SaaS. I prefer SaaS every which way, whether I'm the developer or whether I'm the recipient, I prefer SaaS. It keeps us all out of trouble. Nobody has access to the source code. There's less litigation going forward. So if my business guys are happy with the end result, SaaS is my answer. Then there are obviously strong reps, warranties, and covenants. I don't want to litigate unless I have to, right? So especially with business partners. So we spend a lot of time together getting a sense of, are we protected with a non-infringement rep? people think it's textbookish, but I find when there is litigation, my contracts actually help me a lot. The third thing we do is the B2C companies in the Tata group are generally most impacted by brand infringement. There could be counterfeit issues, fake job offers, and it's different from a B2B company. So the B2C general counsels, I try and get us together every quarter or so to get a sense of, guys, what's going on with Titan? What sort of cases have you seen? How are you dealing with it? How is Tata Play dealing with it? How is Tata Digital, Tata Consumer Products? So there's a lot of sort of learnings within the group so we don't reinvent the wheel. And 4, I seek external advice when I'm out of depth. I don't hesitate to do that. It's a very specialized area and it requires people to really keep track what is the infringement going on and to act within a couple of hours when there is a breach. And as legal teams, we are quick to respond, of course, but you're caught up on other matters. So I rely on external expert advice too.
Thank you.
Does that answer your question?
Yes, it does. And time's up. I've been notified twice. Just to sum up, yes, IP is the backbone of all the successful business, and awareness towards IP policy of the business and efficient enforcement is the key. We will be very happy to take any questions afterwards because he has been waving that time's up. Thank you very much to all my panelists for such a lovely discussion.